Shukran Kumar, Ganesh Prasad Mishra, Prosenjit Paul, Manish Kumar Pathak, Ram Verma, Amit Kumar, Kunal Arora, Charu Saxena, Nidhi Thama, आदेश
शेयर कर दूं आप पेमेंट का मैं जिम्मेदार नहीं यार मैं तो जो करेगा वो अपना आप लेकर रखेगा फिर पेमेंट रिसीप्ट जाके दिखाएगा वहां पे
सही है
सब के पेमेंट रिसीप्ट करता करते हो
So Rao sir and Purushottam sir, can we start now, sir?
IPG अगर आ रहा है
Yeah. Yes. Rao sir, can we start, sir?
Yes, I'm ready.
चलेंगे ऐसे चलेंगे
Yes, ready.
आप तो इसके बाद
Sir. Yeah. So I request all the participants to be in a mood mode. Once the Q&A session, you can on your mic, you can raise your hand symbol. We will allow you to ask your question.
चलेंगे सर चलेंगे
Good evening and welcome you all for this Q&A session of SWAYAM online course on Introduction to Intellectual Property. On behalf of Ministry of Education Innovation Cell, AICT and IIT Kharagpur, I, Dr. K. Elangovan, Assistant Director, Ministry of Education. Welcome all the experts of the day and the participants registered for this program. I am happy to share with you all that 30,000 plus learners have been registered for this program today.
Elangovan, I think there is a disturbance. Maybe you can ask Mr. Hassan Ali to meet. Hemant.
Dr. Pooja, can you mute all other participants?
Hassan Ali.
Hassan Ali, can you mute? Yeah. Sorry for that, sir. Okay. So today we have first speaker with us, the chairman of the IPR course committee, Professor P.V.M. sir, Department of Design and Mechanical Engineering, IIT Delhi. Sir was instrumental in developing this course, and it was almost a tedious process. I can feel past more than 1.5 years in developing the course for UG, PG, and PhD scholars, as well as the content developed for this undergraduate course on Introduction to IT. So, sir, as the chairman of this IPR course committee, and also I request you to address the participants why we have started this course and why IT is important in current scenario. So the platform is open to you now, sir. Yes, sir. We'll unmute you, sir.
Elangovan mentioned. So this is actually the result of a teamwork, and many team members actually participated in this, and many of the people actually recorded the lecture, and you would be actually hearing from some of them. Dr. Purushottam is already here. Dr. Gouri will probably be joining this thing, and there are others who would also be probably speaking to you, who are all part of this particular team. And as you know, this is probably among all the SWAYAM courses, one of the courses which I consider is extremely important. And because this has been a long due that many of the educational institutes and SMEs and other organizations wanted to have know more about the intellectual property, types of intellectual property, how to file, what is the relevance and what is the importance of filing an intellectual property. And this particular course actually covers all these aspects in a very lucid manner. And I'm sure all the people who have registered and who are going to attend this would be extremely benefited or benefiting. And I know Just to give a little glimpse why intellectual property, and I think it's actually it's needless to say, but still I'll probably give a couple of points why intellectual property is becoming central to all the activities which we do. First thing is, this is important for all types of organizations, whether I'm a big corporate, whether I'm in a university, whether I'm an SME, whether I'm in R&D organizations, or whether I'm a startup. Everyone today needs intellectual property, and they may require for varied reasons we can look at, but I think this is something which is needed. I thought I'll give you a couple of situations and then probably we can continue with this. So one situation is, let's say I'm actually getting into a new product development and would like to invest a large amount of money to take this product ahead, make it market ready, and probably even sell in a global market. Now, such endeavors are extremely important if you, extremely fruitful if you have a backing intellectual property for the new innovation which you are taking it to market. Because large investments do require a IP backing in many ways. First thing is that if you don't have an IP and still you would like to go ahead with your product or a solution in a much bigger way, you can't sustain it with very long. So I think from the sustainability point of view, extremely important. And in many cases, you also would like to be a competitive in the market. And also, more importantly, what we are also realizing is that even if somebody, let's say, would like to go with a new product or a solution without an IP, which we have seen in few cases, people had a serious problem of imitations and counterfeits coming very quickly. And it actually overall brings down the brand value of the product itself. So IP is becoming an extremely important for those aspects. Imagine I am a educational institutes, or let's say an SME or a research organization, and I have done proof of concepts. Now I would like to attract a larger investment, or let's say I would like to have a manufacturer on my side. Attracting investment as well as exciting the manufacturer requires a lot of, I think IP is an extremely important in this aspect. We have seen that most of the investors look at IP as a basis for investment. Even manufacturers would like to get into investment provided there is a protection and they have a sustained market for them, at least for some time. This is another thing which is very, very important. One thing which is also seeing that now India also has close to 90,000 startups based on the registrations which are done with Startup India. One thing which we are seeing is that not all startups are actually planning to take their innovation to market themselves. People also want to probably work on their innovation to a particular stage and then do a technology transfer or a technology licensing to bigger organizations and others. If you want to do, you get a value only when you have a strong IP associated with your tech transfer and tech licensing. Because if you just say that I have a know-how, it does add a value, but not a significant value. And that is another extremely important aspects which we are also looking at. And it's also IP is actually through an IP, you're also creating a brand when we are looking at other aspects. For example, in this particular course, I think we'll be discussing about design registrations to copyrights to trademarks and even importance of those. If you really want to build a big brand around your product, these intellectual properties are extremely important to do that, to show that you have a novelty. And also IP is becoming extremely important for in all rankings, whether it's a ranking of an educational institution to a ranking of a country. In other words, if you look at all these aspects, IP is something which is now very central. And it's also now, if you really look at most of the global reports, everybody is looking at more towards creative economy. And creative economy is possible based on the IP aspect. And this course is very important because what we have seen, particularly which is very specific to India, is that in terms of research rankings, we are very high. But I think in terms of translating research into products and solutions, we are still very poor. And I think this translational aspect, the very first step is to acquire IP. In fact, there are now many reports which say in certain areas, India is actually ranked third in the world in terms of research, only behind United States and China in certain areas of research. But if you compare patents in those areas, we are still very, very far. We are in some cases not even in the top 20. So I think if we really want to really benefit from the research which we are doing by converting them into products and solutions useful for society, the very first stage is to have an IP. And I think that's where this course and the overall discussions which will happen as a part of this course will actually help in a great manner. There's another very interesting episode which happened. One of the CEO of a big multinational company who was visiting India recently was also evaluating some of the companies in India, particularly small and medium enterprises. When we asked the innovation potentials of SMEs, one thing which I said is there are organizations which are creating intellectual property, but they don't know that they are doing so. That means I'm actually inventing something, or I'm actually coming up with new products and solution without knowing that there is IP possible in this. And I think even there, we need a great education. And I think this course will help you. Maybe you are already generating an IP. It will help you whether it's possible to obtain an IP or what type of IP. So I think this course we are looking overall as a really a flagship course where the numbers will increase over the years. This is the first time which is being offered. And I'm sure most of the people who would be doing will be extremely benefited as our entire team was benefited in designing this particular course. Thank you.
Thank you, sir. Thanks for sparing your valuable time for addressing the participants today. And also on behalf of the committee and Ministry of Education, I thank for sparing your valuable time as a chairman of the committee, and also the member like Purushothaman sir, Dr. Mohit Dambir, Unnat Pandit sir, Gouri ma'am. So everyone been contributed a lot for this course to bring a shape today, and we can see that a lot of case studies has been brought in with the support of the experts and the committees. And also thanks for our patent office for extending their officers to provide case study for this content, sir. So thank you once again, sir. Thanks for joining this session. Now I request Professor Purushothaman sir, DPIIT Chair Professor of Andhra University and former Chairperson of NRDC, to address the participants on understanding IPR key in knowledge and economy. Professor Purushothaman sir, I request you to address the participants now. Sir, you are not audible, sir. Purushothaman sir, you are not audible, sir.
Unmute, I think, him.
Yes, sir. Now it's okay. So we have unmuted now, sir. You can speak now, sir.
Yeah. But anyway, Good afternoon to all of you. And
So Purushottam sir, can you hear us, sir? Sir, we can hear you now, sir. You can go ahead, sir.
Are you able to hear
Yes,
me?
yes, sir. Yes, sir. Yes, sir. You're audible, sir. Please go ahead, sir.
Okay. Yeah, Professor Rao has already given a why IP. I think he has covered almost every field under the sun. Why we all should know about IP. So, like Gouri madam says, air is everywhere, IP is everywhere. So without IP, no matter exists, or no product exists, or no service exists. So if you look at the scenario, in 1975 and today, and if you look at the valuation of these companies, any company's value depends on what? Its assets, In 1975, if you see the statistics, are you able to see my screen?
Yes, sir. It's visible, sir.
Yeah, that's fine. Thank you. So the topic I've just chosen to talk today is that IPR is a key for knowledge economy. So knowledge economy means we all know what do you mean by knowledge economy. So the knowledge economy is a and production that is based on intellectual capital. In particular, it refers to the ability to capitalize on scientific discoveries and applied research. I think there is no dispute on that. Knowledge economy is always driven by the intellectual capital, and the knowledge is created based on the research and applied research particularly. The knowledge economy represents large share of the activity in most highly developed economies. If you look at countries like China, US, Japan, Germany and all, the products what they market, in the market, they're all based on the intellectual capital. That is why they're able to get higher premium, and because of that, the economies are also of a huge size compared to our Indian economy. So in a knowledge economy, a significant component of value may consist of intangible assets, such as the value of its workers, knowledge, intellectual property, So this is the point I was telling you. In 1975, if you look at the data on the global companies, 83% of the company's value used to be in the tangible assets, and only 17% of the company value used to be in the intangible assets. Tangible assets in the sense the building, the equipment, plant, land, the inventory, the stock, the cash, So 83% of the company value used to be in the tangible assets, only 17% in the intangible assets like intellectual property rights. We all know that, intellectual property rights are intangible assets. So today, if you look at the scenario, is almost, 90% of the company's value lies in the intangible assets like patents, trademarks, copyrights, the softwares, customer data, or the know-how, whatever we call it, So only 10% of the company value lies in the fixed assets or tangible assets. So it's such an important value, the company's values or the economy, it depends upon the knowledge or the tangible assets. So is it not necessary that we should equip with such kind of intellectual property rights? Definitely it is required to meet the aspirations of our youth and the vision of our Honorable Prime Minister. If you want to become a global guru, definitely we need to focus on understanding intellectual property rights, how intellectual property contributes to the socio-economic development of any country for that matter. See, Dr. Rao has already mentioned in his opening remarks, if there is no intellectual property created, what it can happen? The big fish eating the small fish eating the further small fish. The same thing is happening even in the knowledge economy. If your intellectual assets are not protected, the same thing will happen here also. And it is happening. This is what we have been seeing, But on the other hand, if you get your IP protected, benefit, you have got a very strong teeth. You can even resist or fight with the big companies based on the rights protected, rights granted to you by the government. Rights means 20 years exclusive right if it is a patent. So that rights conferred on you legally has given you such kind of a power to assist the bigger players in the market, in the competitive environment. So that's it. That is the power given by the government. So it is important for all the students and faculty members to understand how to create such kind of a IP and how to secure rights and how to monetize those rights. So a great effort has been made by AICTE, and Dr. Gouri should compliment for the kind of efforts she has put in. And again, a tangible asset she has created based on all our intangible assets. It is a wonderful program. I have seen several programs in the area of IP, but I would rate this is the #1 program in the country if somebody wanted to understand the intellectual property rights. And as Dr. Rao mentioned, it is important for academic institutions also having a culture of intellectual property rights. NIRF, we all know that every institute is now being ranked, the NRF National Institutions Framework ranking. We analyzed the data of last year. We found 92% of the institutions, they got only 1 mark out of 15 marks, or less than 1 mark. Majority of them is 0 marks. We put 0 to 1 as one category. 92% of our academic institutions, that is about 1,857 institutions who have participated in the NIRF ranking, they do not have this IPR culture at all. How do you measure the IPR culture is there or not? Whether they're teaching IPR, whether the faculty is doing research and converting their research into products and processes and which are protected in the form of intellectual property, nothing. That is a major concern for all of us as a policymakers, as academic administrators. The scenario is very, very bad. If you see the scenario compared to the Western countries, it's totally different. There 92% of the institutions have got IP culture, but whereas in India, 90 to 93% of our institutions, they don't understand, they don't know anything about intellectual property rights. Program like this definitely benefit, create that kind of an awareness and make our students and faculty at par with the rest of the world. So since there's also a correlation between intellectual property of a country and the GDP of the country. If you see China and US, they are the major leading countries as far as intellectual property rights are concerned. China files around 15 lakh patents, 14.5 to 15.5 lakh patents every year. But whereas, we file only 66,000. And see the economies are also of similar, correlated in the similar fashion. Higher the IPR, higher the GDP of those countries. Of course, US is an exception because whatever patents granted by US are highly valued in the market because in terms of the technical advancement, the products, the technologies, what they develop, they are much superior to anyone else in the world.
I guess
the data is a little bit older, but the trend remains same. There is a strong relation between the IPRs of the country, the portfolio of the country's IPR, and there is a GDP. Higher the GDP, of us to prepare our students, researchers, to build that kind of IPR culture, and also who are the top 5 companies in the world? Apple, Amazon, Microsoft, Google, and Facebook. These are the top 5 companies in the world today. Market capitalization. Again, this data is a little bit old, but the trend remains same. Each one of them are sitting, thousands of patents that gave them that competitive advantage, exclusive rights on that technology. That exclusivity, because of that market advantage, they are able to capture, they are able to emerge as a global leaders. So IP plays an important role if you wanted to grow in the market. That is what we see in all these 5 companies. We all know that how these people have become so rich, IP billionaires and rich gods, Steve Jobs, Microsoft, this gentleman, and our Indian H.C. Verma, who wrote the engineering physics, he also gets a substantial amount as a royalty for selling his book, but he's a great man. He substantially contributes whatever money he gets as a royalty. He contributes to the Prime Minister's Relief Fund, such a noble soul. And the importance of IP, of course, expressed by Rawat also. Just 1 or 2 examples I would like to give here to inspire the individuals, inspire the youngsters in the faculty to give more focus on their research outcomes, so that we do not know the value unless we can market that idea. So, for example, Dan Bricklin, who lost millions of dollars because he did not patent the spreadsheet program what we are using. It was invented by him. So, without a spreadsheet, I think there is no meaningful analysis, or how easy data and compute the data. So because he has not protected his IP, he was not able to monetize the value of the IP. Similarly, Kodak paid over 900 million US dollars for infringing on Polaroid's instant camera patent. This is also one of the major case study in those days, how knowingly or unknowingly, if you copy somebody's patent, the kind of implications. The courts are nowadays are very powerful, particularly IP infringements, IP copycats, one can go to the court and get an injunction and get a penalty imposed on the people who copies your intellectual property right. That is a right by the government, If somebody infringes your rights, you can always go to the court and get a civil and criminal remedies. So licensing of just 3 patents earned 150 million to Stanford University because that created a huge, corpus for them to carry out further research. Recently, there was a course of penalized, somebody, using an internationally renowned company name on his product and is selling his product in the market. So that gentleman approached the company court, and the court has penalized 5 crores penalty for IPR infringement. So these are all very, very important areas are now emerging, and IPR is now globally attracting a lot of attention. So it is our duty to prepare our students and faculty, to educate and to build that kind of a capacities within us. So why IP protection is essential for startups and MSMEs. This point was also touched by Professor Rao. Startups now are the engines of our economic growth. We are emerged as a number 3 in the world in the startup phenomena. But majority of them, still they don't appreciate, they don't understand the value of IP, what they have been pursuing, what they have been creating. So as I told you, if you have got an IP in your business, it gives you competitive advantage. No one can else enter into that business, if you have got a patented technology in your startup, in your MSME. So that minimizes your competition, and also as Professor Rao said, it improves your valuation, When somebody wanted to invest in your company, if you have an IP protected for your product or a process or a brand or trade name, the investors also gives you higher premium for your shares. What is that you are giving it, to them as a equity. So this is also another major advantage for the startup companies. It attracts investors, and also because it protects, if there is an IP built in the company, it protects their investors' interest also, and it acts as a both defensive as well as offensive protection, Your technology, you can go to the court and get an injunction. If somebody says you have copied his technology, you can always argue that I have not copied. Government of India has granted a patent on my technology. I am using my own technology. So such a power IP gives you, in this competitive world. And also it can be a new revenue source also. If you do not want to use your IP for a business, you can also license it, as you was mentioning. IP is essential for exporting any products, particularly pharmaceutical products, to developed economies. And it also helps you increasing negotiating power when you are cross-licensing and joint ventures. And as we have seen, 90% of the companies license the intangible assets. We have also seen the power of IP during COVID times. The people who have generated this IP and who hold this IP, they made billions of dollars trillions of dollars by producing this vaccine. So what I would like to conclude is that, the knowledge, wealth, they are the two sides of the any development process. Now, knowledge means nothing but IP, and if you put that IP into practice, it creates wealth, and spend part of the money, plow it back to do research, bringing out new products, new processes, is always that continuum or that equilibrium has to be maintained so that country will be always is sustainable in terms of development. So Lakshmi and Saraswati, are the two sides of the coin of development or the economy. Okay, so it is very, very important for all of us. In fact, we should made IPR is also a kind of a fundamental right, for all the citizens. The knowledge what they are creating, it should be protected, monetized. Otherwise, that knowledge dies and somebody uses that knowledge. So thank you very much for giving me this opportunity, Dr. Elangovan, and all my committee members. It is a wonderful opportunity to work with all of them and learn many things. And I'm sure that one day our program will be the topmost program in the country. I think I can say, I hope at least every batch, not 10,000, 1 lakh students should register and do this course if we all work together and spread this message.
Thank you, sir. Thanks for sparing your time and giving a very insight thought of IPR and saying that's a knowledge economy. I'm very sure these participants, we have 10,000, 13,000 plus participants registered for this program, sir. I'm sure because that shows the impact of quality of the program and the content developed by the experts like you as a part of this committee. Thank you, sir. Thank you once again for your continuous support and being with us through the journey of this innovation course, IPR course, sir. Now I request our next speaker and the committee member of this IPR course, Dr. Mohit Dambir, Professor of Practice, Innovation and IP at IIT Jodhpur. Sir, I request you to address on when and when not to file a patent. So I request you, and the platform is open to you now, sir.
Thank you, Dr. Elangovan. I would like to thank Professor Rao, Professor Purushottam, Dr. Gouri, and everyone. Good old days and hello after a long. Right?
Yeah, welcome back.
Yeah, I'm in India for a couple of weeks and took an assignment at IIT Jodhpur as faculty at Center of Excellence in IP. But really commendable to see what the seeds, like what we guys sowed, and that's starting bearing fruits. People are coming up, they are moving on. IP in India is improving day by day. Things are getting that kind of traction. I deliberately chose today's topic, and when they ask me, I said everybody will say about patents, IP, and I will say when or when not to file even IP or a patent. A lot of scenario, it goes on. Everybody keeps on educating, and even me too, since long, that we have to file a lot of patents. We have to go ahead in that patents. And in that race, what has happened, I realized to improve the CV, almost all of us, we ended up filing garbage. Mark my words, I'm saying garbage. The situation needs to be tackled in a very diligent manner. We are riding on a very thin sword edge. It may harm us, it may give us benefit. There are many situations, where we look around. IP, yes, indeed it is there. Very important part, like Dr. Purushottam mentioned. I also supplemented. It is our breath. The way we take breath, IP is breath of research. IP is breath of something which we are doing. It validates, it wets up. And like Professor Purushottam in his slide also reflected that Stanford University earned $150 million from only 3 patents, right? We all need to understand the kind of IP we are generating. You can see in the market, I'm being blunt here and being very practical. to all my fellow colleagues, my faculty members, on and off, and I'm sure you guys receive a lot of WhatsApp messages. We have a patent ready, we have an abstract ready, and be the author number 1, 2, 3, 4, and we have these technologies available, put your name, be the inventor. Let me be very clear on one thing, and I'm not sure whether how many of us know that. Form 1, which we all sign while filing the application, is an affidavit. It's a legal paper where we say that I am one of the true inventor of this invention. I'm repeating my words. I am one of the true inventor of this innovation. Now imagine moving down the line, if litigation happens and you people are being brought into the court, right? The inventors, so-called inventors, who are even not aware of that whether what kind of invention was filed or what kind of invention was not filed. What will be the contention? What will be the scenario? So my point is, do ethical research, do genuine research, that's true. File patents, they are necessary, but file your own IP. Do not get carried away by the kind of scenarios which are developing in the country. Of late, that happened in the scenario of research papers. That is going around, and majority of us, we know how things are getting shabby and shabby. And so I come from like kind of the background. I have seen the system. Kapila was our program. It is our program. I am one of the committee member, and so I was the director of innovation cell. We launched it, and thought process, even the definition, Ellen and I worked around it. So my plea to everyone is, file patent. If you see, if you or take the help, like we have IPR chair in Andhra University out there. We have a lot of such resources available from the governments. We have various IP cells, we have TISFs, we have TSICs, we have another patent, DST affiliated patent offices. Try to get your invention validated. Try to see whether it is commercializable or not. Just for the sake of it, why the hell you want to get a patent for? You go, you file a paper, you put in money, and later on, then what will you decide? To improve something for the sake of your profile? Yeah, that is fine. But Stanford getting 3 out of 3 patents, so many $1 million. But do you know, again, a very important thing, what is the grant of patent rate? Actual grant of patent rate? Maybe 40 to 50% would be granting. But what is the commercialization rate of the IP? It's only 3%. Only 3% of patents they get commercialized. It is a worldwide data, it is standard. Now the thing is, again, people, they ask me why I should go and I should file a patent for, I should get a patent. Only thing is, it is a kind of protective insurance. Again, I quote from Dr. Purushottam's slides, big fish and the small fish. If you have a patent, big fish will not come and eat you. On the contrary, as a small fish, if you have an IP, you can go along and you can sell your IP, you can commoditize your IP, you can commercialize your IP, you can get some meaningful outcome of your IP. So the thing is, you need to, an individual needs to, and a researcher needs to typically just vet for sure if it has some commercial value, or it looks like the direction of research is going there. Maybe just file a provisional application, sit for a year, develop the product, understand the market. Always try to look into the terms of ROI, that whether technology transfer is going to happen, whether this ROI, return on investment, is going to happen. It's a win-win situation. Try to look from the startup angles, whether this particular research or IP or patent can down the line bring in, I would be able to develop some product, or if I license it to someone, they would be able to develop some product, or a startup can be formed. So my take is, think from that perspective, India is growing in IP domain. We are maturing in IP domain. We are every day scaling new heights. Number, yes, important. But quality patents, they are more important. So if you look around, 6 lakh patents being filed by US, some 57 odd or 100,000 odd granted. Out of those, if I say like 4-5,000, they are kind of commercialized. Bingo. Until and unless you commercialize your IP, it's no fun. So have the kind of right fit balance. I understand there are government norms. Many of the faculty members sitting here, they have to fill in their career advancement CAS forms where they need to put in some forms. We have some so-called ranking mechanisms whereby we say you file patents, you get so many marks or whatsoever. But frankly, nothing doing. We need to break the shell. We need to break the ice. We need to come up to a level. We need to be realistic. Where you would like to hatch your eggs, only where you are going to get returns of. Think in that direction, think positively, and as said, need be, so anywhere want to reach me up, mohitgambhir@gmail.com. I would just like to sum up, and all the best to everyone, and stay connected. Thank you so much.
So thank you, sir. Thanks for sparing your time and addressing our participants. So now most awaited session for your Q&A. You had a lot of queries which you want to ask with the expert and the Professor Gouri ma'am. So now I request the participants one by one to raise your hand symbol. So we'll unmute, then you can ask your question. Our experts will answer for the same. The participants are requested to raise their hand symbol so that we will unmute. You can ask your question to the expert.
Okay, so am I audible, sir?
Yes, ma'am, you are audible, ma'am, Gouri, ma'am. So I welcome Dr. Gouri, Assistant Professor from IIT Kharagpur, who played a key role in developing this content.
So associate professor.
On day-to-day basis.
Associate professor.
Sorry, sir. Associate Professor from IIT Kharagpur. So, ma'am will answer your questions. Ma'am, yes, ma'am. The session is open to you.
Yeah. It's nice to see after a long time all of you, sir, actually. Okay, so I just share some observations about the course, whatever is happening. Like 12 weeks already we have completed. I'm happy that on the discussion forum, we are getting a brilliant questions. I mean, some questions are like amazing, and a few of questions I have just brought here for the discussion because it was a little bit difficult to write answers because that may not able to convey the intricacies of that particular question. Also, I requested that in the chat box, if any questions are there, Mohit sir is there, Purushottam sir is here. Probably Professor Rao, just he has to attend some meeting, so he might have, but probably he will come back again. So we are here and we will address the question. So what I will do, I will just start with the questions. And the common question I will just address first, and that is something related to examination. That announcement is very important. Related to examination, we have not announced yet the date of the examination. So somebody is like asking that I have missed the paying the fees and that. So not to worry, we will give you sufficient time. We will give you the process for the that particular registration and for the examination. Already you have completed the assignments and a few assignments are due. And the exam pattern I should clarify here, that exam will be MCQ type questions only, just like in the assignments you have saw a lot of like assignments, and that MCQ type of questions will be there in the that final question paper. Again, I should clarify that there is that is a one question actually, that I have attended all the assignments, so whether I am eligible for the certificate. I'm sorry, if you have just attended the assignment, it is not giving, you are not eligible for the certificate. For getting the certificate, you have to complete all assignments. That will count 30% marks, and then the final examination will have a 70% weightage. So the combination will be 100%, and based on that, you will get the certification and the grading of the course will be there. Now, the second important thing is regarding the assignments actually. So 11 assignments we have released, And I know that week 11 and week 12 was a little heavy considering the activities, because 5 tutorials were there you have to complete. And then the week 12, that was like a project completion, that report writing was there. So what we have done, we have released assignment 11 little bit later, that 1 week gap we have kept, so that you can complete the remaining assignments and you can give the focus on the tutorials. We have not still released the assignment 12 actually. So the reason is like this. I hope that now the report is ready, because in the week 12 we have shared with you how to write the mini project, that report. So the time is given to complete that particular mini project completion. So now what we will do, coming Monday we will release the assignment 12. You need not to submit mini project. It is like we will like give you the assignment based on the project, and you have to submit the assignment. The most important thing is like that many times what happens, that we forget to submit, use that submit button of the assignment. Make sure that every time you have used it, the deadline for some assignments is already gone. And that assignment submission is a mandatory actually for the final certification, because we are considering the assignment and the final paper, the combination of these two. Okay, so this was the general common questions were there. Now the specific questions, whatever you have raised. So now date of exam, again, I just tell you, probably it will be in May, or the first or second week of June. That probably the date, May or first or second week of June. We will give you sufficient time to do the registration process and obviously for the preparation. Again, what we will do, we will have one more live session before the examination, because commonly means when that happens, that when we have an exam, we study a little bit in a deep, we can say, try to understand the concepts and all. So probably at that time you will have some more queries, so solve that queries. We will have the another live session before the that examination. So that will be definitely there, because at this point I'm just saying that it is 16:50 almost, we have a 10 minutes only, so I just try to cover up the few questions only. So one question which is, there are few questions, I just start going through that. I had published a research article in 2020 in a journal. Can I register a copyright on the algorithm used in this in that paper? My algorithm was not part of a research article, but results were used. I want to take a copyright on a complete code corresponding to the algorithm used. Please specify whether I can have a copyright on it. So copyright, the two things are very important. Registration is not mandatory. Okay. Now, Berne Convention, that gives us the we can say the privilege that as soon as we write, we get the right over that particular article or whatever we have written. Now here what you have suggested is in 2020, you have published a paper in journal, but you have not shared the algorithm. If you would have shared that algorithm also in that paper, I will say that the copyright will be with you as a author. Okay. Now what you have to do, you are just thinking that you have to take the copyright over that algorithm, which you have not, we can say the, as I am understanding from the question, that it is not in the public domain and you want to do the, you have to take that thing. Definitely you can go ahead and take. If it is a original, obviously that check will be there, 30 days time will be given for the getting you the diary number. That 30 days time will be there. If somebody feel that it is like some queries or some opposition they want to file, just 30 days time is there, that you, that procedure you know already. So the answer in one line is like that, yes, you can go ahead and you can file the you can take that registration, you can do the registration of copyright. But again, if you will not do the copyright registration, that way also you are getting the right the protection over the creation. I hope I am able to clarify the answer. Next is like what will happen if after filing the provisional specification on further refinement of the invention, we find the on nearing complete specification, then the invention is out of scope of provisional specification. Okay, need not to worry about that. If you feel that the application, suppose you have filed the provisional specification, you have developed for 12 months the experiments and the Gargate, whatever it may be, you have completed that thing, and now you are saying that it is going out of scope. So there is a provision like a divisional patent. So unity of invention is very important. So you can go for a divisional patent, and that specific arrangement is there, and you can have a two patents. Obviously, the priority will be from the provisional filing date. I guess I'm able to clarify the query. If not, you just put the query again, or if any specific thing you want to know, you can just write down, and I will clarify that. Okay. A few questions now from chat box item. How will we know the marks of our assignments, ma'am? For the first assignment only, the score was given. For other assignments, scores was not given. Okay. We will just check out the guidelines of AICT, and we will get back to you. I will share with you the email, and if how you can get the idea about your performance in the assignment. We will try that you will get the whole, we can say, the score of the assignments, and we will just try to do that thing. Okay. Whether all assignments have reached to you or not, you need not to worry about that. It will be there if you have done the use the submit button, then definitely we have received your assignments. Okay, then regarding the submitted assignment, exam fees. Okay, as a country, are we ready for infringement enforcement for trademarks or copyright? Do you think our law should adapt flexibility in these terms? Okay. Considering the intellectual property, you probably knowing that recent development in Madras High Court, there is the special bench for IP is now active. It was active only in Delhi before. Now, just means 2-3 days back, Madras High Court have that bench now active. And considering the trademarks and copyright, I will say that yes, high courts are doing the lot many cases are already there with the high courts, and you can just see that the enforcement. I can just give you the one example, very classic example of a Krish. Ram Sampat case, copyright case is a very popular, and you know that thing, and the trademark related cases are also. So you need not to worry about enforcement. Probably this reason of asking this question may be because delay in the procedure is there, but I will say that although the delay is there, the justice is also like delivered. So enforcement is possible, and it is there, it is working, and it is there, means you need not to worry about the enforcement, it is there. Okay. Patent agent
Good evening,
exam.
ma'am.
Yeah, please.
Yes, ma'am, one question is there. I'm Vidisha, ma'am. We like your lectures and especially your style of teaching. So thank you
Thank
so
you.
much for that. Ma'am, the question is I did one patent in 2021 and
Okay.
now I got FER also.
Mm-hmm.
So now for the further grant in BIG, I
Mm.
want to establish one private limited companies. So,
Okay.
ma'am, for that, we are the 6 people in patent filing. So for
Okay.
the company registration, do I proceed with all these 6 or the 2 member can do the company, and what are the rules and how I should proceed with the company and what things we should keep in mind for the
Okay.
company
Now,
registration?
these 6 names are as an applicant or inventor?
Both are same, ma'am.
Both are same. Okay. Now, one more thing. Actually, some cautions. Actually, if uh, the company will be based on solely on this patent.
Yes, ma'am. But I have other 3 patents also, but
Okay.
two are in line of filing, and one more is also filed same in 2021. So we
Okay.
are thinking all 4s we will go with the one company.
Okay.
And
Now, okay, I got the point. Okay, six people and a private limited company, and the patent applicant and inventor. Now I just it's a very good scenario actually. So I just clarify this. Uh, uh, One thing that if you want to see that, okay, you just said that only 2 people should go for the as a founding member, or 2 directors are starting with the private limited company. Actually, this is
yes,
your choice. Patent Act is not talking anything about it. It is not coming in the purview of a Patent Act. It's coming under a Company Act. Okay, and the rules regulations of Company Act and the Ministry of Commerce will come into the picture, because that is the authority. When we talk about patent, the
yes,
DPIIT is coming into the picture. So how many members you have to take for the company formation, that is not as per the no, Patent Act is not talking now. But the observation, the cases which come actually, when you
yes,
are considering a founder member, you know that there should be the compatibility. there should not be issues. I just cite one example and then you will realize what issues come actually.
Yes.
Or other two examples I can share, and that will be probably the learning for your decisions actually. The one example I'm just sharing, that when I was practicing, there was a case. Form 1 is there, right? In Form 1, you sign, the inventor signature is there and the assignee signature is there. Obviously, means both are signing there.
Yes. Yes.
Now, what happened? That patent is filed, FER received. The patent was like near to the grant, and some because of some reason in that time gap, whatever happened, we don't know. But there was a conflict between, or there was some dispute between the inventors. Now, what happened, that when the process came to the end, actually, at that time, some signatures were required, and that inventor, that maybe there were 3 inventors actually, and that one inventor was not ready to sign actually. Okay,
Yes.
and without its signature, we are not able to complete the procedure. That was the scenario. Luckily, what happens, we keep the forms in triplicates and all that thing, so we could able to manage that issue. But otherwise, that would have been the very hard time for the applicant. So just
Right.
just this is a one scenario. Second scenario, which is in IIT Bombay, I come to, I just handled that thing. They have started this private limited company, and 2 members were there as a founder members. Now what happened, they have hired that 2 or 3 more members as obviously in their company. And obviously in the starting phase, you are in like a good we can say relations and all.
Right.
And in that, what happened, they have written the name of that inventors in the applicant name actually. You know that legal rights are with the applicant, legal rights are not with the inventor. Now what they have done, they have put the name of applicant also, means their name as a applicant also. Now what happened, that so after some time again, the reason we never know what happened, but there was like dispute and there was a issue with handling of that patent. So what I suggest by these 2 examples is like that when you are starting the company, it is a very serious activity. So
Yes.
so you have to be very careful that whose name should be there, because that will create the hindrance, the issue in your entrepreneurship activity, and that is not like affordable when your product is like at a mature stage and all. And if some conflict arises, then that will not be good actually. So be careful. And generally the suggestion is that if you keep a less number as a founder, that is a good idea actually. That is the case.
Yes.
And
Yes.
again, you have to take a NOC from everyone for this particular thing. That written NOC is very
Sure.
important.
Sure,
Okay,
sure, ma'am. In our case, ma'am, 2 are the students, so that they are don't want to go ahead,
but
and
you
we
have
4 are
to,
the professors.
yeah, yeah, but please take a
Yes.
NOC. Written document is
Yes.
very important. Okay, because
Sure. Sure.
otherwise, and one more actually, one more caution I'm just sharing here. If inventor is like 6 inventors are there, that is another experience I have, that if 6 inventors are there, make sure now only, make sure now only that how much contribution everybody have done. So maybe someone might have done 50% contribution, but someone might have done only 5% contribution in the
Right.
that, right? So just
Right.
write down that contribution, take a signature of everyone, so that there will be the, whenever revenue comes actually, whenever money comes, the fight starts. So, so at that time there should not be any issue. You should be very clear, okay, 5% contribution, that much only percentage or revenue will go to that particular. So just take caution. Okay.
Right. Right.
But
Thank you
congratulations
so
that
much.
from patent, like you are now moving to the commercialization, and that is a very positive side.
Yeah, thank you so much, ma'am. It's a great help from you. Thank you, ma'am.
Thank you. Thank you. Okay. So, okay. If we have missed any assignment, how can they are submitted? Frankly, if due date is over, you are not able to submit it. But we are not considering all 12 assignments. Probably we will take into consideration only 8 based assignments. So you just be sure that if you have done that 8 based assignments, okay. Every metro city India has designated counterfeit market. Will IP enforce them some in near future? Okay. Counterfeit products is a big problem actually in trademarks. And means round around means you go and everywhere you find the counterfeit product actually, or trademark infringement is there. So many times it is very difficult to take action against every infringement. Okay, so just like piracy, that movie is like pirated copies of movies are like available online, and then that is, but that there is another business model also. We will not go into details of that because there is another business model. But counterfeit problem is a problem. Counterfeit market or counterfeit products is a big problem. uh, a superintendent of police, like they are like trained, they have given the power to confiscate the material, and that power is with them. So any FIR goes to them, they are like they can take the action against that particular thing. I hope not only in metro city, I will say everywhere you can see the counterfeit products. Okay, so that is the scenario. How will we know the marks? Okay, now patent agent exam is on 7th May 2023. Hope this will be useful for that too. Yeah, means I will just say that when you have gone through the actually the basics of IP and the patent week. In the patent week, I have taken one session. Mohit sir has taken 3 sessions, and Unnat sir's one session is there. So I will just say that basics will help you definitely. But there are another courses also. Just because what happens now, being engineering or being science students, it is goes very difficult for us to read the Bare Act in the start. So if you have some background in that, it goes very easy to understand the Bare Act. And unless until you know the details and intricacies of Bare Act, patent examination, you will not able to qualify. I tell you frankly this particular thing, because that is Bare Act is very important. And second important is a drafting skill. And for drafting skill, you at least, I will say that you should go through at least 10 patents reading. You just practice. If you are not able to, it goes difficult actually when you take a first time that document, patent document, and start reading. So in roadmap for patent creation, we have recorded 1 week completely how to read a patent. Probably that will help for a patent drafting actually. So I guess if you do that thing, then the base will be clear. And Bare Act, you have to go through all sections, rules, schedules, you have to go through. Okay, so that is the scenario. Okay, fees, for exam fees, you have to go obviously online. That procedure is there. What if first assignment is missed? There is no problem. I have told you that only 8 assignments we will consider. Okay, then there is okay. Here is a one question. If after attending the course, I want to do one write-up of a say content in some magazine, can I use the content after writing in my own words with the proper reference to the course? Now, just please note that SWAYAM courses are CCB by SANA licenses there. So what is the meaning of that? Attribution is mandatory. Commercialization is not at all allowed. Obviously, you have to follow the rules of the copyright. No plagiarism, no copy paste, obviously. You have already mentioned that in own words you want to write it. Then obviously that may not be the original article, but yes, that is an expression, and that is allowed. And then share alike is very important, that with the same license, if you have developed that thing, it says that a essay is a share alike, so you have to share the content in the same license form. You cannot say it is a copyright of you. You got the point? So you cannot say for this content as a you have the copyright. So Amita madam, so if you are saying that, and if you put the C and you say that copyright, then we are not like probably we will not means that may not allow, because this content is under CCBY SANA actually. Okay, so that is a kind of a scenario. Now, what is the eligibility for taking up the exam? You have already attending the course, so you are obviously eligible for attending the examination. Just make sure that you have completed the assignments, because assignments that 30% weightage is there. Okay, so we have to take that thing. If I am working on some literary work and can see some related work already copyrighted, okay, I can only see the title or can check the work done by author fully. Okay. If second question related to that, if I can see title only, that what can be done to make sure it is not similar to earlier work done? Do I have to write mail to or contact those authors? Third question is, if I file and it is objected, then what will happen? Okay. So obviously, when you see the copyright website, that the office website actually, copyright office website, you can get the name of the author, the applicant, and then the title. Actually, you are not getting access to the complete detail the work. So yes, you can just contact the author, obviously, to get to know that particular what that work is, because the author is the owner, or if author is not, obviously if he has transferred that right to somebody else, that applicant, so you have to contact the applicant to know the content, actually what exactly that particular work is. That is a, I guess, first thing. If I can see title only, what can be done to make sure it is not similar to earlier work? So obviously you have to request for that content, and then you can, once you get that, then you will obviously able to check that particular thing. Third, like if I file and it is objected, then what will happen? Okay, so it's like you want to make sure that whatever your copyright application is there, it is free from, or just like in patent we check the novelty, and then you can like safe that once I file, I will get the grant and all that thing. Unfortunately, I will say that it is very difficult in copyright. But what we can say that the examination, whenever that examination of your copyrighted work is going on, but it is not that substantial or that way like a patent's examination happens. The provision in the law is like that when you file the application, 30 days time is given, that if somebody want to object after getting you diary number, 30 days time is given, and if somebody want to object, they will definitely object the registration of that copyright. So that provision is there to just safeguard that there will not be a wrong registration. Okay, so you need not to worry about that. That will be taken care in the due course actually. So I hope that all three questions I am able to answer. It's already 5:08, so we have to take permission from Elangovan sir whether we should continue or close, because there are so many questions, but we have to take a permission from Elangovan sir. Sir, if you allow, then only I can take further questions, sir. Pooja madam and Elangovan sir. Okay, until they
Yes, ma'am, please go ahead, ma'am.
Okay, okay. So I have registered only on 28, okay, in which the examination was given an option. Regularly, I have completed also. I guess if it is a late, okay, I guess if you have done the registration in February, we have given you the um, like chance to complete all the assignments, because we extended the assignment submission date. So, but you have to take an examination for the certificate, not with only assignment you will able to take the to get the certificate. Our grandparents, there is another question by T.N. Prabhakar sir. Our grandparents and great grandparents are having many things that are patentable without technology support, I hope. Okay, yeah, the traditional knowledge comes into the picture in that particular case now. So TKDL library is already there, and trade secrets are already there, and traditional knowledge is there. So that particular arrangement is already there in IP. And okay, so that is there. Then is role of IP for the institutions other than academic institute and industries. Okay, as an individual also, you just check one IP. You have just mentioned institution and academic, industry. In what role IP for the institutions other than, I see IP is like you take a homemaker also, and if she prepares a recipe book, the copyright will be there, and she can like have create wealth from that book, definitely. So IP is like not limited to institute or some industry organization, definitely they are creating wealth out of that. But obviously the individuals, MSMEs, so anyone who is like a creative in nature, the whatever the creativity is there, depending on that creativity, the different types of IP is there. In capsule, one of the capsule, Mohit sir has already answered that question, that why there are so many different types of IPs are there. That was the question, and we have answered that question in one of the capsule session. So whatever the type of creativity is there, the types of IPs are there, and definitely you are able to protect that based on that particular like IP. And once you create IP is for wealth creation. If you like just now that the the 4 patents and the group of 6, 2 patents already that filed or something like that she has just shared with us. So definitely something like that, if it is there, anybody who is owning that will able to create a wealth out of that IP, right? I guess we should take 2 more questions and we should close because already it is a
Chapter
5.
complete.
Okay. Up to, okay, I guess this is not related to our IP, so I just skip that thing.
हमारा कितना रह गया?
For exam, so that we can get the certificate. What is the process? How to apply? Okay, I will just skip that. Hence, we have to online assessment for the month of March. CBSE, I guess that is not related to this. Okay, I guess I have covered this, and then one last question I will take because this is something copyright related, and we will close. Okay, and if you have any question.
Ma'am, Professor Gouri, ma'am, if you have time, we can take few more questions.
Okay.
Questions.
Okay.
I can
Okay.
unmute them. If they raise their hand symbol, I can unmute. They can also ask their questions, ma'am. You
Okay,
can
sir.
take that actually.
Okay, sir. There is one question. Like this question is a little bit longer, but I will just read that and I will try to answer that question. It is this is from Mr. Gopinath sir has asked this question. Okay, the question is like that. Copyright protection comes automatically as soon as the work comes into existence. The registration, just listen carefully how the content what it is written. The registration of the content is not mandatory, but it is essential to exercise the exclusive rights in case of a infringement. Suppose I am publishing a paper in an international journal and transfer my copyright ownership to the publisher. However, I am not sure whether the
देखो जो
papers
अकेले
published
करना
are
उसकी है,
registered by the publisher due to practical
जो
challenges.
फ्री के साथ है प्रोफेशन
Now,
वो भी है, तो ये इस तरह है, ये चीज समझ लगे.
okay. So the question is like that. We are not sure. Means just check that statement. Suppose that I am publishing a paper in an international journal and transfer my copyright ownership to the publisher. However, I am not sure whether the paper published are registered by the publisher to the practical challenges. Now, just we have to be very sure. If your paper is published by the publisher, you are immediately, means obviously you have transferred the copyright to the publisher. Okay, you have transferred the copyright, that form is there. Generally we do this activity only when the paper is accepted, right? Once the paper is accepted, we have to submit the copyright and that form, that and then you are many journals ask us the copyright form early also, means as soon as we are submitting the paper they are asking for the copyright form. So both the scenarios are existing. Now make sure that whenever we are doing this activity, a Bern convention, we know about that the registration is not mandatory. So as soon as this, whatever you are creating it, obviously you are getting the right. So you need not to worry about the creation, means the registration and all. It is already, you are the owner. When the paper is published in that journal, obviously you are like authors of that particular paper. That is already there. You need not to worry about the registration. It is automatic. Okay, however, I am not sure whether the papers published are registered by the publisher. Then, will published papers and unregistered copyright material? There is no question of unregistered copyright material. It is a automatically copyright registration is there due to the Bern conventions. You need not to worry about that. Now, the next question is, if someone infringes, whether he or she liable to the author or owner being an unregistered copyright material? If any lawsuit to be initiated, will it be by the author or the owner? Request you to enlighten. Okay, now this happens. Okay, that you generally when paper is published, this case will be very rare, that after publication of a paper somebody is like doing the infringement. Actually somebody is like copying. Okay, now the 2-3 scenarios I am just take, because this is the scenario what happens. First scenario I take, you have written the paper. Somebody without the publication of you have already done the theft and published the paper on his or her name. First scenario, very worst scenario. Second scenario, you have published the paper and a part of that paper is somebody copied as it is. That is another scenario. Then the third scenario may be like that, like not a complete that major part, but small part is like a, but which is not again the as per copyright rule, but that is like a copied or used by somebody. The fourth scenario, the perfect scenario or the expected scenario is like that somebody is referring, giving attribution, and just referring that, not copy paste. There is a like in own words they are writing what exactly is there in that paper, just like literature review we are writing. Four scenarios I have given. Now the first scenario, if copyright theft happened without the publication, author is the owner, he have a right to initiate the action, right? Again, very important, copyright is non-bailable. 6 months jail minimum is there, and it's a very serious offense. Okay, so the first scenario, if without the publication somebody have like in the like the theft happens, that is the like author has to initiate the action actually. If it is published in journal and if you come to know about that particular usage by somebody, that suppose you have published in X journal and somebody have generally this never happens because most of the journals are following the copyright check very seriously, but still in unfortunate scenario, if some Y journal have published that thing, then it is your duty to send a communicate with the Y journal, and obviously you have to give the proof, and you have to obviously share that this is the like copyright theft. You have to communicate that, and obviously the journal owners will take care of that particular situation. You need not to worry about that, but you have to just take care that one email communication is good enough. Generally in good journals, that kind of a scenarios that they will take good care of that. Okay. Third scenario, again the copyright theft is there. Maybe this happens in academic system, like in the PPT somebody else content is used, in the seminar report somebody's content is used, in the project report somebody's content is used. Then for that the provision is like that, according to generally in the institutes or in the organizations, disciplinary committee is there. You have to communicate with the disciplinary committee, and you can take the immediate step, communicate, give the proof, and they will take care of that. Okay, so I hope I have answered that question. Next question is like that, it is related to patent. Gopinath sir only asking, the filed patents will be published after 18 months from the priority date. If I want to file a new patent, then how can I check my novelty or a potential infringement with the patents? Those are filed but not yet published, because I don't have any access to check these unpublished but file patent. Frankly speaking, nobody have that access. Not only you, nobody have access to that 18 months. It is like a black box actually. And therefore, whenever we do search report, we clearly say that 99% the novelty search we have like a sure about this novelty, but 1% we cannot give that guarantee. And that 1% is because of that 18 months thing only, because this 18 months, the patents which are just, suppose today I prepare the search report, then the immediately 18 months back, I really don't know which are the patents filed, and nobody knows actually in the world. That only that applicant and the inventors know what patent they have filed. And therefore provisional application is a very, very important, because to secure the priority, that particular arrangement is there, that as soon as you are sure about that your patent is like in 12 months you are able to complete, you have to file the provisional. That is the reason we always emphasize on a provisional. So that is that is the second question you have asked. And the last question, in week 11 tutorial 5 you have mentioned that only patent agent can file the patent application in patent office. I was thinking that a patent application can be filed either by true and first inventor or his assignee, either alone or jointly with any other person. Request you. Yeah, see, sir, there was a scenario that I have already clarified that thing. In the court of law also, if it is your case, you are allowed to defend that case. But I have clarified it very clearly that if you are filing or trying to that application on behalf of somebody, suppose I am here, I want to file I am like a not patent agent, suppose then the somebody is comes to me and this is that you file the patent, then I'm not allowed that to do that if I'm not patent agent. I'm patent agent, so I'm allowed to do for somebody else. Just like advocate can give you the in the court of law, he's like defending you, and he's taking whole care of your case. So assignee, definitely, as he is the owner of that particular patent, he is able to file the patent. True or first inventor, obviously he has to take permission of the assignee. He don't have any legal right. So suppose I am a professor in IIT, and if I go and file a patent, I am not allowed to do that. I have to take permission from IIT, and IIT only will file the patent. And so assignee has a right, inventor don't have legal right. Okay, so the application will be by assignee, inventor, the signing signatures are required. Okay, so two scenarios you can say. But somebody else patent, somebody else is filing, who is not patent agent, is not allowed. That is very important. Okay, I hope I am able to clarify, and I guess we should conclude. If you have any questions, there are few more questions, but I guess we should not take it. Is already 5:22. Long time you are here, like right from 4 o'clock. So you can just write in the that forum. We will answer the questions there, and we can have another live session to take the more questions, and we will solve the queries. Okay, but complete the assignments and study well for the examination. Okay, thank you so much for your active participation and very brilliant questions you have asked. Thank you for that brilliant questions. Okay, thank you so much. Over to you, Elangovan sir.
Ma'am, I don't mind. Some four participants have raised their hands, ma'am.
Okay, sir.
You
No
can just
problem.
quickly clarify their doubts or not.
Please, sir.
I think T.N. Prabhakar, sir, can you ask your question, sir? What is your doubt in it? T.N. Prabhakar, sir.
Yes, ma'am. Yeah. Actually, I filed a patent in 2013, ma'am.
Okay.
But only in 2023 I got it granted.
Okay.
So the 10 years lapse, whether it can be compensated or it is a natural thing for everyone, because 10 years gap is.
Okay. This is a very common kind of a scenario is there, but we should know that our right starts as soon as we file the patent. Our right starts. So suppose 2013 you have filed the patent, you got that application number, your right started from that particular day, sir. So probably you have to start the entrepreneurial activity right there actually. And there is no any compensation for a grant date and all that thing, because 10 years like time of for the grant, many times we are also contributing that late, because 6 months time is there for FER submission. If we have done it in 1 month, we are saving on 5 months actually, or 48 months timeline is there for examination requests. Sometimes we do it at the end in the 48 month, and then the queue is like there, and then your patent application goes into the queue at the back for the examination. So we are also contributing in that actually, late examination and late grant actually. So the answer, very clear answer to your question is that there is no any compensation as such, because the government gives us a that sovereign of the state is given us a right from the day we file the application. Okay, I hope
Thank you, ma'am. One just question, ma'am. What special financial schemes are available for commercializing the patents, granted patents?
What kind of because there are so many commercialization schemes are there, 100 plus I will say the schemes are there for commercial, and sir is there actually, Purushottam sir is there, NRDC is actively working on the commercialization actually.
Where I can get the details? Sorry for the interruption.
Yes, sir, please.
Where can I get the details about all these things?
Sorry, sir, I'm not getting.
I mean, you said there are so many schemes are available. Where I can get the details of all these
details? I just hold on. In entrepreneurship and IP strategy, I have dedicated one session on that schemes only. So in the week 7, so you can just check that week 7, the schemes for the IP commercialization. It is already there.
Okay.
See, Gouri madam.
Yes, sir, please.
Yeah, you see, as such, you will not get all the schemes under one roof. You know, depending upon the domain. If it is a biotechnology, you have to go to Department of Biotechnology website. If it is science and technology, if you have to go to DST. And there are agencies like TDB, Technology Development Board. There are a lot of organizations are available, as madam says, but depending upon the domain, you need to go to that particular agency.
Thank you, sir.
For funding, yeah.
Thank you, sir. Thank you.
The next question is from Shukla. Shukla, you can ask your question, please.
Yeah, thank you, sir. I am Dr. Atendra Shukla. Am I audible?
Yes, sir.
You're audible, sir. Please go ahead.
Sir, I have a granted patent, madam. But I need help in evaluation of this patent for commercial prospect. Like, if I am trying to commercialize it, how much I should ask from the potential technology transfer party, what could be the because market surveys and all those things or other parameters, we are not trained or experts in gauging those things, like, so
Right.
how to do that?
So actually, there are few agencies which do the valuation. You are saying evaluation,
Yeah.
evaluation and valuation. These are the two different things. Actually, when we are talking about that
Yeah.
evaluation is the first step to do the valuation. Okay. Now there are different methods and all the cost method, income method, and different approaches, qualitative, quantitative. So that all things are there. But frankly speaking, none of the method works. That also I should say. But yeah, currently in the market, we can say that people are using hybrid mode actually for the valuation, and there are agencies which do definitely the valuation of the patent. And like we are also like means one of my student is also was working in the IP valuation, so we have also like methods to do that valuation, IP valuation. But yeah, means if you want to do the some law firms are there, and maybe you can just if you want help from our side, you just write to us. We will try to see how we can help you in that. Okay.
Okay, thank you very much.
Yeah.
Next, Majumdar. Majumdar.
Good afternoon, ma'am.
Yeah,
we
good
have
evening, sir.
This is Dr. A. Majumdar, Director, School of Mines and Metallurgy from Kaji Nazrul University, Asansol.
Yes, sir. Yes, yes sir. Okay.
I have actually published, my one of my patent, which is in the published this thing, and maybe within 2-3 months the examination will be coming. But point is that here the mini project what you have given in our 12th this thing, can I use this mini project with my patent, whatever I have?
Definitely, sir. You can, means you have in hand very good case study then, and you can just follow and you have already done, so you know the intricacies in IP filing, and probably now if you could focus on IP commercialization, that will be much helpful to you for the taking that patent further. Okay.
Yes,
So
yes.
no problem, sir. Yes, sir.
No
But
problem.
good
We
thing.
can go ahead.
Yes, sir. Yes, sir. Please, sir.
Thank you, ma'am. Thank you so much. And the teaching you have been doing is really excellent.
Thank you, sir. Yeah, it's a team effort, sir.
Things. Thank you, ma'am. Thank you so
Yes,
much.
sir. Yes, sir.
Yeah.
Thank you.
Dr. Vidyasha. Dr. Vidyasha, you want to ask your question?
Yes, sir. Actually, I asked initially only, and ma'am answered it very nicely, and
Yes,
it
yes,
was clear. Thank you.
Okay.
Thank you so much, ma'am.
Thank you.
Thank you. Thank you. So yes, we should conclude then,
Yes,
and the remaining
thank you, ma'am.
questions we
Gouri,
will
ma'am,
take in
for
the
yes. So thank you, Gouri, ma'am, for clarifying all the doubts of the participants. I'm sure we clarified all the doubts raised by the participant. On behalf of Ministry of Education, Innovation Cell, AICT, and IIT Kharagpur, I thank all the participants for sparing their valuable time and participating in this event. I hope that all the queries has been resolved here. I thank once again the chairman of the committee, Professor Rao sir, Professor Purushothaman sir, and other committee members. And special thanks to Gouri ma'am for coordinating all the activities and answering the questions. And special thanks to my colleague, Dr. Pooja, Innovation Officer, who have been communicating on day-to-day with every one of you, sending mails and communicating. Thank you, Dr. Pooja, for again continuously coordinating with all the participants and make sure that you're clarifying their doubts. Once again, I thank you all and looking forward to meet you in future online session. Thank you.
Thank you. Thank you all. Thank you.
Thank you. Thank you so much.
Thank you.